Hello, everyone. This is quite a special episode of the Unisoft Question. Today, I have Ed Waitzer, former chair of Stikemans, longtime Stikemans partner, former chair of Ontario Securities Commission, former VP of the Toronto Stock Exchange. And you're not even 65, Ed, right?
No, I'm almost 68 next
how,
week.
How are you today?
I'm doing fine, thank you.
How did you manage to do all of these things? So seriously, I mean, it's a big deal. All these three things that I mentioned are a big deal. I don't know a lot of people who have done that. Are you a superhuman? Do you have superpowers? Tell us a little bit about it.
Life is a bit of a random walk. There's so many interesting things to do. And I think the answer is I didn't limit narrowly my frame of vision. So I ended up at the stock exchange because I went to law school never intending to be a lawyer, and got back involved in policy work when I came out of law school and ended up at the stock exchange. I ended up at Stikemans still not intending to be a lawyer, but renting space from Stikemans early on because I needed a home. It turned out to be a great group of people and a great organization, and life happens. I left Stikemans several times to go to the Securities Commission, to go down to Chile. Again, opportunities arise, and sometimes you just have to follow your instinct and your interests and not kind of cling to what you've got.
Did you come a full circle and started renting space from Stikemans again recently when you retired?
Yeah, renting would probably be. They've given me the space now. That's the advantage of. But yes, when I put a retirement policy in place at the firm when I managed it, and with the idea of getting older folks out of the way, because reputations in law tend to have a large tail and get in the way of younger people having opportunities. Rather than staying on with the firm as counsel, I decided I'd rather have a little more distance so that I just don't have to worry about what the firm thinks about what I'm doing. And so I still have kept an office and my assistant at the law firm, but I don't have, and I still work with people at Stikemans who I've worked with for decades, but I don't have any economic ties to the firm anymore.
I usually talk about my guests' roots. It's really important to me. I really want to know about those things. And I usually start by asking where the guest is originally from. Are you originally from Toronto?
No, I'm from Virginia, Norfolk, Virginia. My folks moved to Canada when I was young, so I went to school in Canada.
What was it like to move to Canada? How old were you?
Oh, I was a young kid. I was preschool, so it wasn't my decision. It was my father had been in a family business and decided he wanted to be a little bit more independent and bought a small business up here, and it was kind of striking out on his own, but it had nothing to do with me. I remember it, but it wasn't a big event for me.
Have you ever felt the pull of America, being Canadian or being an immigrant in a sense, living here in Canada next door to the US? Have you ever felt this pull? I know that you worked in New York for a few years.
Yeah, I've spent a lot of time in New York. I was there for 3 years, managing the Stikemans office in New York, which was a great chapter and sort of great adventure in my career. And I spend a lot of time in New York because I'm an opera buff. So I get down to New York all the time for art and opera and other things.
You know, you're not the first guest of the show who was brought here from the US by their parents. So another guest, for example, is Julia Hennigsberg, and she's president CEO of Holland Blueview Kids Rehabilitation Hospital. So she's American too.
Yeah.
And I think she followed a somewhat similar path. I think she came to Canada a little bit later in life than you. But I'm really curious. You obviously maintained your ties to the US. Your parents grew up in the US, they're American. Do you feel any kind of conflict between your Canadian identity and your American identity? Or is it true what the rest of the world thinks, that Canadians and Americans are the same thing?
Canadians and Americans aren't the same thing. The United States is the one country in the world that kind of viscerally believes in markets, and it manifests itself in every possible way for good and bad. A lot of the work that I've done, especially on the policy side, has reflected the fact that Canada plays a unique role in the world, and not just because it's a resource-based economy, but because it effectively is a bridge between the United States and other parts of the world, particularly Europe, where the cultures are so different and the political systems are so different, and the regulatory frameworks are so different. But Canada, because it's so highly integrated economically with the United States, but very different culturally and politically, sort of can often play that bridging role. And that's been something that I've been able to take advantage of from time to time.
Please talk about your parents. Who are they? What they did, and how they raised you. This is really interesting.
My dad was a entrepreneur, passed away several years ago, but an entrepreneur, reasonably successful entrepreneur, small businessman. Started out in the wholesale drug business, got into chemical packaging, ended up buying a small brokerage firm and became involved in the securities industry, and actually stayed involved in the securities industry until I got involved in the securities industry, and then decided to get out. I think partly because he had had a bad experience kind of being in a family business and didn't want to be in the way. He had done his thing, and so he decided to make way for me and space for me. It's not something I asked him to do, but it's something that he did. So he was a serial small businessman, entrepreneur. My mother combined being a mother, a housewife, with a bunch of careers. When my dad was in the brokerage business, she got her license and was a research analyst, wrote the research reports for the brokerage firm. She was a commercial real estate broker. She was an interior decorator. So she went back to school and got her MBA. So she sort of continuously challenged herself intellectually and had her own career.
Why did you say you didn't want to be a lawyer when you went to law school? And what did your parents have anything to do with that?
No, not at all. I pretty much left home at a pretty young age. I had been involved in setting up a free school, and in a bunch of sort of student politics stuff. Didn't graduate from high school. Got involved in policy consulting during the Trudeau government, the Pierre Trudeau government, and at a certain stage decided it was time to get a degree, and applied to law school, not on the basis of my academic record, but on the basis of sort of a mature student, even though I wasn't all that mature, and got in. And the object of going to law school, my focus at the time was, and to some extent still, on changing the world. And at the time, it was a time of life when, most of us kind of didn't worry about finding a job or having an income. We kind of knew that there was always opportunities available. So going to law school was really acquiring tools to help me be more effective in changing the world, and never intended to practice law. Ended up articling for a guy named Ian Scott, who later became Attorney General, but at the time was counsel to Tom Berger on the McKenzie Valley pipeline inquiry. And I basically called him and said, I'd like to work with you on the inquiry. And the understanding was, I had no interest in being asked back, becoming part of the firm. I just wanted the experience of working with him. And so that's how it played out. And when I finished articling and got called to the bar, I went back into the policy world.
I really love how you just called someone up, and a very important person just asked. This theme came up in my interview with Justice Sawson, the importance of asking and how people underestimate the power of asking. I really appreciate this story. You worked as a corporate lawyer all your life. You never litigated, correct?
Correct.
Okay. Do you think that litigation,
except when I was articling,
yeah,
Ian was an appellate counsel, so
right,
I wrote factums for him.
right. Do you think that litigation and corporate law are just two different professions, or just what, as we call this profession in Canada, so being a solicitor is different, completely different from being a litigator?
No, on the contrary, the partner who I have spent the most time with at Stikemans over my career is a litigation partner. And again, part of that is, I've always enjoyed sort of being out at the edge of the law and, where possible, shaping the law. But I can give you a long list of either transactional work or policy work where it was a combination of corporate law and litigation. So, starting with BCE, where I acted for the board of BCE, or Magna, or the list goes on. So it's, corporate law and litigation are tied together because corporate law is so dynamic, and the way corporate law evolves isn't by amending the statute, because there's not a lot of political currency in reopening corporate law statutes. It evolves through litigating cases. So the oppression remedy has evolved through litigation. Directors' statutory duties have evolved through litigation. And litigation, I mean broadly, because it's also cases that are heard by securities regulators. And, there are a bunch of different ways that the corporate law framework evolves, but it's all litigation.
What is the biggest difference between how litigators think and how corporate lawyers think?
I think good corporate lawyers think two ways. One is how to get things done. And they don't feel constrained by the law. They see the law as a tool to getting things done. And if they're really good, they also think it's a little bit like Wayne Gretzky. It's not where the puck is, it's where the puck's going to be. They think about the trajectory of the law and expectations around the law, and how you can use that and shape that. Litigators think about the law. Like their focus isn't on getting deals done. Their focus is on winning cases. or fixing the law sometimes when the law clearly needs to be developed in a certain way. But their focus isn't transactional. It's around a set of facts and how you frame the facts to get a desired outcome.
You said that litigators are focused on fixing the law. Do you think sometimes litigators break the law because they're so focused on the case at hand and they ignore the larger policy implications or the larger context? And sometimes they take positions that seem untenable just because they want to protect the best interests of their client, but they win because they're good. And now the law is sort of screwed up because it worked for this particular case, but now for everybody else, it's not going to be so good.
Yeah, I wouldn't call that breaking the law unless they are misrepresenting facts or there are some famous cases. The Abu Ghraib case where it turned out that the then I think Deputy Attorney General in the United States misrepresented the law, failed to cite the leading case before the tribunal, and it later came out. Ironically, he was trying to protect the administration and was rewarded by being appointed a judge, which is, the American system. But that's unethical. But arguing effectively and getting to an outcome that may take the law in the wrong direction isn't unethical. And I guess you have to have a certain degree of confidence that over time those things sort out. It's like a pendulum. You don't always get good decisions out of the judicial process, but over time, and judges don't get to choose their facts or cases.
Exactly.
But over time, the trajectory of the law is pretty clear and reasonably predictable and responsive to social expectations and norms.
When I was saying breaking the law, I wasn't suggesting that they were breaking the law or breaking any kind of rules. I was using the word break in the sense opposite to fix, like breaking a machine, sort of making the law go in the unexpected direction. So in your interview to the Canadian Lawyer magazine, you talked about the influence of the courts or on the corporate law and on the development of the corporate law. And you brought this up again just now when you said that litigators affect, or the courts affect, corporate law and its development. So aren't you a little bit upset that litigators, people who don't care about deals, people who don't day-to-day involve themselves with corporate governance, develop corporate law? Shouldn't people like you develop corporate law? So shouldn't it be more through statutory regulation where legislatures consult corporate lawyers like yourself rather than leaving this to litigators to influence judges and then have judges make decisions that develop corporate law?
There's no perfect system. So what you describe is what happens in Delaware, where corporate law is a business. It's the main engine of the Delaware economy, and where there's a committee of lawyers and judges who review the statute every year to make sure that it's relevant and responsive to the needs of corporations and their stakeholders. So it's a very dynamic statute. In most jurisdictions, including Canadian jurisdictions, as I said, there's very little, no government is going to be elected because they've done great policy work in amending a corporate statute. There's no political currency there. So the system doesn't lend itself to what you describe. And courts have been pretty good. I think the system has a high degree. When you talk about fixed or broken, I think of the system as having a high degree of integrity in the sense of structural integrity. It may take time, and there are always some bad cases, but over time, corporate law has evolved, and when you compare Canadian jurisprudence and American jurisprudence, Delaware is more robust. But for instance, the oppression remedy, which is administered by the courts in Canada, is by far the most potent shareholder and increasingly stakeholder remedy, far more potent than any remedies under Delaware law. The decision of the Supreme Court of Canada in BCE, which extended or affirmed the extension of directors' duties to the corporation as including stakeholders, was way ahead of and remains ahead of U.S. corporate law statutes, which are gradually getting there. So there's no, and I'm just comparing those two systems. We could look at Europe, which is different again. They all work in their own way, and it's very contextual. But to go back to your original question, I think the relationship between lawyers and between corporate counsel and litigators is symbiotic. As I say, I have spent more of my time with one litigation partner at Stikemans than anybody else in the firm over 40 years. We almost know how we each think. His skills are in framing issues and arguing. My skills are in negotiating and thinking through some of the policy implications. But we work together seamlessly.
You praised the oppression remedy regime in Ontario just now. The oppression remedy is, protection of minority stakeholders is one of the goals of corporate law. There are other goals, for example, protecting certainty and stability. There are other goals, I'm sure. So in your view, what is the biggest problem with the corporate regime, corporate statutory regime in Ontario right now?
I think it works pretty well on the oppression remedy, and I've written an article on this. What you just said is probably an accurate description of the law, which is that it is designed to protect shareholders, and particularly minority shareholders. My bet is that it will increasingly be used to protect other stakeholders as well, including stakeholders or interests that may not be directly representable. So, for instance, future generations or the environment, in response to externalities that corporations produce. So, and I think the existing law allows for that, but could be clarified to be clearer that it allows for that. So I see that as an emerging sort of field in corporate law, but I've also suggested that the law could be clarified to facilitate that.
Speaking of the speaking of collaboration between litigators and solicitors, I'd like to bring up the commercial list here in Toronto. Do you think that this specialized court is part of Ontario's efforts to improve the corporate regime in this province?
Yeah, it's been a, and this goes back a long way, but it has been a huge contributor to evolving high quality corporate law. And I'll give you two examples, and I say this, when we did the Air Canada restructuring, I can't remember how many years ago it was, it created a bit of a political furor in Quebec because although Air Canada was a Quebec-based company, we decided to bring the restructuring not only in Ontario, but before a particular Ontario judge who we thought was uniquely capable of handling the complexities of that case. Lots of huffs and puffs in Quebec. When it came time to do the BCE transaction, same issue came up, and for better or worse, the board of BCE decided that the transaction should be governed by Quebec law because BCE was a Quebec-based company, and in part because of the political backlash that had happened in Air Canada. The result was a good trial. We knew it was going to get litigated. The result was a good trial decision, but a very confused and split decision at the Quebec Court of Appeal, which took us to the Supreme Court of Canada. The good news is we got great law out of the Supreme Court of Canada. The bad news is that the deal never proceeded because by the time we got to the Supreme Court of Canada, we were in the jaws of the financial crisis. So it's interesting to think back and say, if we had done that transaction under Ontario law, what would have happened? And I think what would have happened is the deal would have gotten done. We wouldn't have gotten the Supreme Court decision. So you win a bit and you lose a bit. But the commercial list has been a huge advantage for Ontario, and some great judges.
And what was the name of the judge on the commercial list?
For Air Canada, it was Farley, right?
Farley, okay.
Jim Farley.
Okay. So do you think that, you just mentioned the Quebec Court of Appeal, do you think the coexistence of two different legal systems in Canada makes Canada a more or less attractive jurisdiction for corporations?
Sorry, the question again?
Do you think that the coexistence of two legal systems in Canada, Quebec and common law, make Canada more or less attractive jurisdiction?
It's it's very much at the margin. You can argue it's marginally less attractive because there's that added complexity. The reality is that there's been a very high degree convergence between the two legal systems. The major law firms operate on a national basis. So it isn't really a barrier to getting things done. There are distinct differences in the civil law system in Quebec. And in some areas that's been, Quebec has been at the leading edge in developing concepts that have then bled through to the rest of Canada. So when you think about notions of fairness in contract law or tort law, some of the leading cases come out of the civil code or interpretations of the civil code.
There are two tiers of law in Canada, in my view, and maybe in many other countries as well, in the US for sure. There is a tier where law firms like yours, like Stikemans, operate, the Seven Sisters, law firms that are the regulars on the commercial list. It's a very closed circle. And then there is the tier for everybody else. And it's not a criticism. I think it's just a statement of fact. And the question is, do you think that society simply distinguishes between issues that are important to the society and at large, such as, the Air Canada case, such as a multi-billion-dollar deal where many jobs are at large, at stake, and so on, and then individual cases, a car accident, a motor vehicle accident, or debt collection, things like that everybody else is bringing to the court. And we have two different streams in Ontario. We have the commercial list and we have the regular civil list, at least in Toronto. So do you think this is an accurate description of reality? Do you think it's justified because some cases have societal implications, and only large firms or so-called elite firms should handle them. And then everything else is such a low stake situation, then that pretty much everybody, every lawyer can be entrusted with dealing with that.
I'm not sure I agree with your characterization. I think the stratification is actually more on the corporate law side than on the litigation side. And then to the extent that the transactional side of law generates litigation, it feeds through, but you can't, a small practitioner or a small law firm can't do large transactions, and on a deal like BCE, at any point in time, there were probably 30 or 40 lawyers at Stikemans working on the transaction over 2 years. That can't be handled, and with various degrees of specialized expertise that you just don't have in a smaller firm. And the other side is, if you're the board of a BCE, you want to go to a firm that has a reputation, in part to protect yourself. So there's very much a stratification of work on the transactional side. On the litigation side, it's not an accident that a lot of the best litigators have left big firms and set up boutiques in order to avoid the constraints that big firms throw up. So they learn their skills at big firms doing transactional work. But a litigator isn't constrained in the same way. You don't need 40 litigators working on a case. You may need 10 or 15 if it's a big case. But so I see less stratification, less structural stratification on the litigation side compared to the transactional side.
You're right that almost all so-called elite litigators came from the big firms, or let's put it this way, the elite litigation boutiques were founded by lawyers who came from big firms. Yeah. McCarthy's, for example, is a factory of such litigators, right? So do you think this large firm tier that's more or less settled in right now, more or less stable, the tier of law firms that large corporate boards trust, do you think this tier is impregnable? Do you think no new entrants will happen?
No.
What's going to happen?
Absolutely not. And, I can, at various stages, as certainly when I was managing Stikemans and we thought about merging with other firms, or domestically or internationally, or, someone could set up a group of top-rated securities lawyers could set up a boutique tomorrow and capture very significant market share. They may not have all the practice areas, and even a firm like Stikemans, which over time has narrowed its focus to sort of high margin transactional work. So, it doesn't do family law or criminal law or wills and estates anymore. So we've shrunk, or the firm, I shouldn't say we, the firm has shrunk rather than grown and specialized. But I think the market, there are clear barriers. And if you look at, law firms are pretty conservatively managed. So the status quo tends to perpetuate, and the tiers have stayed relatively static. But I think that's contestable. And every once in a while you see somebody like Waleed Solomon, who basically develops a practice out of nothing and leverages that to very aggressively capture some of that top tier work for a firm that historically didn't have that work.
Do you think technology will allow individual lawyers to do what only large firms could do before, even if they don't have the expertise necessarily, but just pure tech?
It's a great question. I'm not smart enough to know. I suspect the answer is yes. And it raises interesting questions for the whole law firm model of how, the apprenticeship model of how younger lawyers develop experience and judgment. So I suspect the answer is yes, but I'm not smart enough to have figured out how that disruption will play out.
Speaking of technology, since you were chair of Ontario Securities Commission, I have to ask you this. What do you think about cryptocurrency?
You should ask some of my kids who invest in it. I don't invest in things that I don't understand, and cryptocurrency fits that category.
What is your vision for the corporate law in Ontario or in Canada for the next 10, 20 years? What's going to happen? What's going to change?
I think, and it's not just corporate law, and as you probably know, I've written a lot about this over the years. I think the law tends to follow public expectations, almost in parallel to how political machinery does. And I think, our expectations are changing. Our focus is changing pretty radically and in a very exponential way to a focus on how we address systemic risks in society, and many of which are global. So they're not just the purview of domestic corporate law. And we see that playing out in areas like the pandemic or climate, but it will spread to issues like inequality, all of which are issues that, 10 years ago, any academic would have said this has nothing to do with corporate law. And today, everyone almost takes for granted that this is at the core of corporate law, not because it's referenced anywhere in any statute, but it's because what society expects of corporations.
Ed, I want to thank you so much for this interview. I really enjoyed it.
My pleasure. Likewise.